Welcome back to Florida Criminal Law TV. I'm your host, Stephen G. Cobb, attorney at law. We're talking about sex offenses, and specifically we're talking about defenses, and I want to relate a conversation that I had a long time ago. Now, this person came in, they were charged with a sex offense, we were able to get a bond, and he said, "Mr. Cobb, I don't understand. There's no evidence against me." I said, "Really?" He goes, "Yeah, there's no DNA. They took DNA from me, they took DNA from her, they checked her panties, they even checked her vagina. There's no DNA, none whatsoever. They didn't find any DNA, and she went to the hospital almost immediately after we had sex, and they didn't find anything. So there's no evidence." He went on to say, there were no witnesses. There were no witnesses who even saw us when we first got together, because I didn't meet her in the bar, I met her in the parking lot, and we started talking, and that's how we ended up hooking up. So there are no witnesses, there's no DNA. I've made no statements, because quite often an investigator will say something like, "You're not under arrest, you're free to leave." Translation, I'm trying to avoid having to read you your Miranda warning. That's what that really means. But people get sucked into that and they go, "Oh, well, let me tell you what happened. No, we didn't have sex, but yes, I met her." Or, "Yes, I met her. Yes, we had sex, but it was consensual." Both of those things establish the element that, yes, the person did know the other person. Or, yes, they not only knew them, but they did have sex. Prosecution has proved these kinds of things. So when people start chatting, that's what happens. And this guy says, "I didn't make a statement." And he had already recounted there was no DNA. He went on to list out several other different types of evidence that was not present, that was lacking. To which I replied something that everybody should remember. Testimony is evidence. And he goes, "What do you mean?" I repeated myself. I said, testimony is evidence. "Well, can't you get this dismissed? I mean, what's wrong with you? I paid you good money. Can't you get this dismissed?" Right away, I'm realizing, yeah, this guy's just as much of a problem to deal with as I thought he would be, which is very common when people are under stress and they don't use coping with stress during criminal prosecution. If you run into a scenario as a lawyer and you're defending criminal cases and people want constant hand-holding chat sessions in the office or a weekly phone call, what that tells me is they're not dealing with stress, and they confuse counselor at law with mental health counselor. And let me help you with that. I'm not a mental health counselor. No lawyer I know in this field is. I'm sure there are some, but most lawyers are not equipped to be mental health counselors. So please use coping with stress during criminal prosecution for one reason above all else: it works. And this person was not using that, and he had a real problem understanding that in certain cases, yes, no DNA evidence is an absolute defense that would blow the case out of the water. But in his case, because facts matter, and every case has factual dissimilarities, it meant that testimony was evidence. He had a factual dispute, and I could not get it dismissed because none of the four grounds under the Florida Rules of Criminal Procedure for dismissal of cases applied. So in that scenario, we had to go to trial. So when you're analyzing your case from the perspective of a family member, from the perspective of someone who loves someone else who's falsely accused, or especially if you're the defendant and you've been falsely accused, don't delude yourself into believing, "Oh, well, there's no DNA, I didn't make any admissions, there's no video evidence, there are no photographs, there are no witnesses, so I'm just home free, I'm going to win, I don't even need to hire a lawyer." That's called how to go out the back door, or especially if you don't listen to your lawyer's advice, go out the back door for the longest possible sentence. So when it comes to defenses, and we've covered a lot of ground in this series, and we've still got some more to go, always remember that just because you have a defense does not mean necessarily that it is the defense that automatically wins your case.